Chuck Michel, California civil rights attorney, is with us. Chuck, thank you for your time, sir. Let's get right to it. What does the decision yesterday by the Ninth Circuit mean for Peruta and for right to carry?
Well, it's not time to pop the champagne corks yet. The Attorney General could appeal her. The court denied her request to intervene, and also denied the Brady Center and a couple police groups' requests to intervene. That's a very promising sign because it may end debate on the Peruta case per se. She can appeal that decision en banc, and again, the same math applies. There's 2/3 liberal and 1/3 conservative judges on that Ninth Circuit court. So they may very well want to hear this case. In fact, I think they do. So she can still try and do it that way. But even if that doesn't happen, there are several other CCW cases, several other licensed carry cases that won because the court basically cited to the Peruta ruling and said, in light of our reasoning in Peruta, these cases need to go back down to the district court level for reconsideration. Any one of those cases could go up en banc and conceivably after en banc go to the Supreme Court. So we may have Peruta as the law of the land for a short time, at least in San Diego, but any of these other cases could jeopardize that ruling if they went up and lost, assuming the Peruta case itself doesn't.
Okay, so like I think there's a case out of Hawaii called the Baker case. Is that right?
Right. We've got Baker out of Hawaii. You've got Richards out of Yolo County, and that sheriff has already asked for en banc review. So it seems like if the time runs out for the Attorney General to do anything else with Peruta, then it'll just move over to the Richards case or the Baker case. Or there are another half a dozen at least cases queued up, and most of them are stayed in the Court of Appeal waiting for a final determination in the Peruta case or one of these other cases.
All right. And so, Chuck, what are we looking at? And I realize, the courts operate on their own time system. Clearly, that's the case with Peruta. But how many more steps are there, possibly, before this case could get up to the Supreme Court level?
Well, she's going to have to appeal for an en banc decision very quickly here if she wants to overturn this ruling on her intervention request. And I expect that they will rule on that pretty quickly. They're not going to set oral arguments on that kind of a procedural motion, on a procedural ruling. They're going to dispense with that pretty quickly and then get to whether or not to take the case en banc, consider her pending en banc request. And I expect that won't take nearly as long as this has either. There are some time restraints on how long the court can take to deal with en banc review. So it should speed up from this point on.
All right,
I know we've sat here for 8 months waiting for this ruling, but I don't think we're going to have to wait that long again.
All right, that's some bit of good news. Chuck, listen, I appreciate you coming on the program, sir. Thank you very much for the update, and look forward to talking again soon.
Always a pleasure, Cam. We'll keep fighting the good fight.
Yes, sir. Chuck Michel joined us from Michel & Associates, civil rights attorney out there in California, with an update on the Peruta case.